Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 11 and 12 on the speed of 90 words per minute. Start. In view of the averments made in the applications, we are satisfied that delay has been sufficiently explained, and considering the facts and circumstances of the case, gravamen of the matter, and also the divergent views taken by the same judge of the High Court in the same case vis-a-vis different accused persons on same question, we consider it our duty not to throw away petition on the ground of delay. The explanation offered by the CBI of movement of file so as to condone the delay, so as to subserve the ends of justice, deserves to be accepted. No doubt about it that the CBI ought to have acted with more circumspection and ought to have followed the CBI manual. It is regrettable that we are receiving majority of the special leave petitions filed in this court barred by limitation, not only on behalf of the government but also by the other private litigants. Not only that the special leave petitions are preferred with the delay, but in refiling also enormous time is consumed, and this court, in order to advance substantial justice, is not throwing away cases only on limitation. Sufficiency of cause has to be judged in a pragmatic manner so as to advance cause of justice. No doubt about it that litigants are supposed to act with circumspection within limitation, and that there should not be delay, and latches and state machinery should not be differentiated vis-a-vis with the private individual in the matter of filing the appeals, petitions, etc. However, in the facts and circumstances of the case and considering the averments in the applications, we deem it appropriate to condone the delay in filing the appeals in this court. In this case, we are surprised at the conduct of the CBI in such important matters, how such delay could take place. The CBI ought to have been careful in filing the special leave petitions within limitation, considering the factual matrix of the case. The criticism made by the senior counsel for respondent is not wholly unjustified. CBI ought to be guided by its manual. If CBI fails to act timely, people's faith will be shaken in its effectiveness. Let the director of CBI look into the matter and settle the responsibility on a concerned person. In important cases, Director CBI should devise methodology which should not be cumbersome as reflected in these cases. Otherwise, in future, Director CBI cannot escape the responsibility for delay in such cases to be termed as deliberate one, which is intolerable. Being the head of the institution, it was the responsibility of the director CBI to ensure that appeals were filed within limitation. There should not have been delay in filing special leave petitions at all. Resultantly, we set aside the impugned judgments and orders passed by the High Court, allow the appeals, and direct the trial court concerned to expedite the trial and to conclude the same as far as possible within a period of 9 months from today. We must note that this is the third case which this court has noticed in a short span of 2 months, where in a case of suspected poisoning, viscera report is not brought on record. We express our extreme displeasure about the way in which such serious cases are dealt with. We wonder whether these lapses are the result of inadvertence or they are a calculated move to frustrate the prosecution. Though the FSL report is not mandatory in all cases, in cases where poisoning is suspected, it would be advisable and in the interest of justice to ensure that the viscera is sent to the FSL and the FSL report is obtained. This is because not in all cases there is adequate strong other evidence on record to prove that the deceased was administered poison by the accused. In a criminal trial, the investigating office, the prosecutor, and the court play a very important role. The court's prime duty is to find out the truth. The investigating officer, the prosecutor, and the courts must work in sync and ensure that the guilty of punishable by bringing on record adequate credible legal evidence. If the investigating officer stumbles, the prosecutor must pull him up and take necessary steps to rectify the lacunae. The criminal court must be alert. It must oversee their actions and, in case it suspects foul play, it must use its vast powers and frustrate any attempt to set at naught a genuine prosecution. Perhaps the instant case would have been further strengthened had the viscera been sent to the FSL and the FSL report was on record. These scientific tests are of vital importance to a criminal case, particularly when the witnesses are increasingly showing a tendency to turn hostile. In the instant case, all those witnesses who spoke about poisoning turned hostile. Had the viscera report been on record and the case of poisoning was true, the prosecution would have been on still firmer grounds. Having noticed that in several cases where poisoning is suspected, the prosecuting agencies are not taking steps to obtain viscera report, we feel it necessary to issue certain directions in that behalf. We direct that in cases where poisoning is suspected, immediately after the post-mortem, the viscera should be sent to the FSL. The prosecuting agencies should ensure that the viscera is, in fact, sent to the FSL for examination, and the FSL should ensure that the viscera is examined immediately and report is sent to the investigating agencies or courts post haste. If the viscera report is not received, the concerned court must ask for explanation and must summon the concerned officer of the FSL to give an explanation as to why the viscera report is not forwarded to the investigating agency or court. The criminal court must ensure that it is brought on record. We have examined the merits of the case and held that the appeal deserves to be dismissed and is accordingly dismissed.